When you're a building contractor, they take somebody's money and apply it to something else. It's called violation of the Builders Trust Fund Act, and it's a felony, and it's punishable. It used to be punishable by not less than 6 months in jail, minimum sentence of 6 months. I tried several of these when I was a prosecutor. Nobody ever charges them anymore. In my opinion, every time you do this, it's a crime as well as a civil document. Plus, you're not licensed to do what it is you're selling your services for.
Zoom.us/J.
Stay where you are. We'll make it work.
Okay. I'm in Elkhart, Indiana.
Yeah, that's fine. Mr. Kemp, you're back. It's 3 o'clock. We'll start in a minute. Ms. Smith, you're here.
Yes, Your Honor.
This is the time for our small claims matters. We have one case where we have both parties so far. That would be Andrew and Christina Noble versus Joe Kemp. Mr. Kemp is here. Annette Smith is here from Dealers Auto. Mr. Bradley is here. Bradley is here on behalf of Custom by Design versus Kenneth McPike. So I'm going to do the case where both people are here, and then we'll see. The others may result in a default. Mr. and Mrs. Noble, would you come up here and have a seat? You're actually on this side, the plaintiff side. And someone named Michael Rogers has joined us. Mr. Rogers, which case are you here on?
I'm here for the Amy Geider small claims.
All right. You're here from Embers Community Credit Union?
Yes, Your Honor.
How's everything in Marquette?
It's pretty nice today, low 70s.
All right, we'll be with you in a minute.
Thank you.
So it looks like we've got one contested case and a couple of defaults. I usually do the defaults first. Maybe I should do that. All right. Hi, have anybody come in for small claims? All right, thanks. Bye. All right, let's first do our defaults, then we'll do our contested case. First case I'm going to call is Embers Community Credit Union versus Amy Geider. File number is 261009. SC, which stands for small claims. We don't have much cross-pollination between Marquette County and St. Joseph County, but occasionally we have some. We had some contacts with the prison from time to time, and
It sounds like it.
I was friends with the prosecutor up there, Gary Walker, for a number of years. Mr. Rogers, what's your position with Embers Credit Union?
He has a charged off unsecured personal credit union or personal loan.
What's your job?
Oh, I'm a collections officer.
All right. Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, Your Honor.
All right, Ms. Geider was personally served with notice of today's hearing. She's not here either virtually or live. Now you can tell me about the debt.
Okay, she has a unsecured personal signature loan no collateral behind it. Balance on it as of today is $937.05 plus court costs.
Court costs in this matter are $82.50 and $64.26. Total default judgment would be $1,083.81. I find by default that the defendant is liable for that amount.
Thank you, Your Honor.
Now, as you know, getting the judgment is the easy part. Getting the money is the hard part. But I think you know what you're doing, and the next step would be a discovery hearing. And this debt isn't overwhelming. It's the kind of debt that maybe they would simply pay. At any rate, she isn't here. You've supported your case with sworn testimony, and I've granted a default on your behalf. Total amount is $1,083.81.
Thank you, Your Honor.
You're good to go. Have a good day up there.
You too. Thank you.
I read a number of books at the Upper Peninsula. Don't go there much, but I read about it. All right, Ms. Smith, let's take up your matter.
Yes, sir.
Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, Your Honor.
You must have done a couple dozen of these by now. And
Yes.
I think you've been sent. What's your position with Three Rivers Auto?
I am the accounting and payroll clerk.
Well, I just discovered this. We don't have service on Hoosier Car Store. They owe you lots of money.
Yes.
On Lima Road in Fort Wayne, and it doesn't appear they were able to serve them. Are you getting these caught up, or you've got tens of thousands of dollars worth of unpaid customers? It's hard to run a business that way. We getting to the end of them, or do you still have more to come?
Oh, I still have more.
Oh my. No service. Continue at least 60 days. All right, we'll try again, either in probably
Okay.
September. But we can't do a default unless they know they're being sued and we don't have service on them yet. All right, you're good to go. I'll see you next time.
Okay. Thank you, Your Honor.
All right, next we've got Custom by Design versus Kenneth McPike. Mr. McPike rented a dumpster and never paid for it. He's being sued in the amount of $821.35 by Custom by Design. Bradley, I didn't get your last name. Would you state your name again?
Yes, that's Dasso. That's D as in David, ASSOW.
What's your position with Custom by Design?
President.
Mr. McPike rented a dumpster from you, didn't pay for it, and then ghosted you. We do have certified mail service, so he is subject to default. Have you heard anything?
Nothing. I've tried to text him, email him, call him, but he just stopped, answering. At first he said, he was going to pay, but then he just disappeared on me.
All right, I find by default that he owes you $821
Thank you, Your Honor.
plus court costs of $66.25.
Okay. Any idea the best way to collect that for me?
I'll tell you here in just a minute.
Okay.
As you heard me say, not completely in jest, getting the judgment is the easy part, getting the money is the hard part. He has 21 days to pay this. Or he's subject to collection. What we do is we start with what's called a discovery subpoena. Now, if you don't, in a civil case, you don't have to come to court. If you don't come, you automatically lose and a default judgment enters against you. We don't have debtor's prison and the court doesn't go out and collect the debt. But you can subpoena them to come to court to answer questions about their ability to pay on the debt. What's their credit card number? What's their social security number? Do they have any vehicles, snowmobiles, wave runners, trailers, or thing that could be sold to pay the debt? They have to come to that because it's a court-ordered subpoena. If they don't come to court, they're subject to contempt and being arrested. And several times each year, somebody gets arrested for not showing up for a personally served subpoena. That generally gets the debt paid. Like I said, you don't have to come to the court case. You have to come when you get a subpoena. So I would wait at least 21 days. If he hasn't paid anything, come to the court or contact the court and ask for a discovery hearing and a discovery subpoena. And that will compel him to meet you face to face or by Zoom. Okay.
I will do that in 21 days then.
All right. Well, hopefully he'll get this and say, gee, I better pay this bill. It doesn't usually work that way.
No.
All right. Good luck, sir.
Okay. Thank you very much. Bye.
All right, now we're down to our contested case. I was going to do the contested case first and see if any of the other people showed up. But it doesn't appear any of them are going to, and then everyone would have had to just wait. So let's take up Andrew Noble and Christina Noble versus Joe Kemp. Mr. and Mrs. Noble are here with me at the courthouse. Mr. Kemp is here by Zoom. I want everyone to please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
Now, Mr. Kemp, you can put your hand down. You've been through this about 5 or 6 times, and here we are again. Let me tell everybody that we're in small claims court. It's a separate division of the 3B district court. Claims are limited to $7,000. Neither party is allowed to have an attorney in small claims court. We don't strictly follow the rules of evidence or procedure. We'll allow hearsay like letters and quotes and estimates and that sort of thing, as opposed to a lot of foundational difficulty. There is no appeal from small claims court. There's no formal record being made. Neither side is allowed to have an attorney. Once the decision is made in small claims court, it's final. There's no appeal from it. Either party has the right to remove the matter from small claims to the general division of the court. But if you want you to do that, you have to tell me before we start. Mr. and Mrs. Noble, are you ready to proceed here in small claims?
Yes.
Yes.
And Mr. Kemp?
Yes.
All right, Mr. Kemp represents himself as Joe's Carpentry Service. He does not have a license, and he needs a license to perform what he's doing. He's been sued 6 times or more. He got charged with a criminal offense back in 2019, which in my opinion, probably every one of these is. Mr. and Mrs. Noble, your contention is you paid Mr. Kemp $6,000 deposit to do a job, and he never did any work and did not return the deposit. Is that accurate?
Correct.
Mr. Kemp, what do you say to that?
Okay, when I took the money from them, and after that I got sick. I was in the hospital all winter. But then when Mr. Andy told me he wants his money back, I got a hold of the company where I deposited the money for materials. And they kept telling me they're getting it back to me, and that's what I told Andy. And I called him again this morning. I said, I got court this afternoon. I need an answer. Because they told me that as soon as they get this order that we cancel, have somebody else take it, that they would refund me the money. And I said, well, I told them this morning, I said, I got to have an answer. They said they'll get back to me, but they still haven't gotten back to me as of today. But
all right, well, here's the deal. First, in one case, they charge you with larceny by conversion as a felony, and the matter got bound over to circuit court. When you're a building contractor, they take somebody's money and apply it to something else. It's called violation of the Builders Trust Fund Act, and it's a felony, and it's punishable. It used to be punishable by not less than 6 months in jail, minimum sentence of 6 months. I tried several of these when I was a prosecutor. Nobody ever charges them anymore. In my opinion, every time you do this, it's a crime as well as a civil document. Plus, you're not licensed to do what it is you're selling your services for. But clearly, you took their money and you didn't do the work, and then you got sick. I believe you went into this intending to do the job. Your quote says, yes, no hidden costs. Well, here's a hidden cost. I give you $6,000 and you give me nothing in return. So maybe you can use this to light a fire under where your $6,000 went, but you didn't deposit well, I don't know what you did with it, frankly. But you owe them $6,000 plus costs of $86.25 and $43.18 for a total of $6,129.43. Because you got sick, I see you're on oxygen there. Are you going to retire?
Yeah, I'm totally on disability. I can't keep working, so they got me on total disability. What I want to do is just straighten this all up with Andy and his wife. They were really good to me. I'd done other work for them, and I just want to get their money back and what I want to do. Because I quit construction. I quit everything.
All right. Now, maybe this order will help you pry the $6,000 out of wherever it went so you can return it to the nobles. You still live in Coldwater?
Yes. Yes, Your Honor.
And Mr. Kemp, you're still on M66?
Yeah.
All right, I find by trial, actually the defendant acknowledges he owes the $6,000. It's pretty straightforward. They put down the deposit, you didn't do any work. I'll accept the fact that you got sick, but they're entitled to their money back. So, Mr. Kemp, you have 21 days to pay this, or they can pursue collections. Mr. and Mrs. Noble, although he's been sued several times, in several of the cases, you did end up paying the people back. So hopefully you can get your money back and you can go on to get another person to do this. At any rate, Mr. Kemp, I made a finding that you owed the money. Continue to work on those people. We're going to send you a copy of this judgment that says you owe the money. You can show it to those people and say, I need this money back. All right, do you have any questions?
No, do I just send it to them or should I take it over to them?
Well, if you get it, you can take it over. But you can send it over by certified check or money order. It's $6,129.43.
Okay, about 6,130. About okay.
I'll send you a copy of the order that shows the amount.
I just
All
want
right,
to tell
let's-
Andy and his wife that I'm sorry that it went this way. That was not my intentions at all.
All right, I'll accept that. But as I said, you aren't licensed to do this anyway. So I'm glad that you're retired and hopefully this won't happen anymore. All right, you're good to go.
Thank
you. All right, let's see if he can get his money back. As I said, he did pay some of the cases, he did pay the people back. So I'm gonna have the court officer take you out to the counter. You'll get a copy of this order. He has 21 days to pay it. And I don't know if he gave it to some Amish supply company or what. See where this goes. If you can get the money back and you can get all or some of your money back.
We got multiple stories from
Yes.
Joe, Your Honor.
All right, another bad hair day here in Centerville. Good afternoon, we're back. Our California visitors have started their journey back home. We have one guest here in the court this afternoon. We have our landlord-tenant docket. We have 2 general civil cases at 145, some more landlord tenants, and 4 small claims matters. Good morning to sunny Florida. Our friends must be driving back to Detroit. We already have a couple people in the waiting room. More still. All right, I'm going to go ahead and start the live stream. Hopefully there aren't any terrible clinkers in here. Good afternoon, Mr. Baig. This is a new area. I don't know if I've had you on landlord-tenant cases before, but welcome back to Centerville.
Thank you, Your Honor.
We've got everybody we need, so we can start our all right, Miss Amber Boyer. She's got a couple things open. Miss Boyer will come back to you in a bit. All right, well, let's take up Doug and Marie Klein versus Sarah Bingaman. Chad Spencer is here on behalf of the plaintiff. Ms. Klein is here. Ms. Bingaman is here by Zoom. This is our second hearing. We determined that through June, rent was $1,800. It's now July. We learned also Denton Patterson and his daughters were there, although they're not on the lease. Plaintiffs want the defendant to pay the rent or vacate. Mr. Spencer, what's the status here today?
Your Honor, there's been no rent paid to my client since our hearing last Tuesday. So at this time, there'd be another $1,200 owing, Your Honor, for July, which would bring the total rent due to $3,000, Your Honor.
We talked about that last week. That didn't sneak up on us. We got costs of $247.47. So the total is $3,247.43. Ms. Bingaman, we had talked about that coming on. You indicated you were going to talk to DHS. What can you tell us at this point?
DHS prior to this hearing had already put in an application for SER, and it was declined due to the fact that I make too much. And I also got a hold of legal aid and kept getting the end of it. I didn't get any speak to an actual individual.
All right. Well, what do you expect that legal aid could do for you?
Well, considering that on every avenue, it seems like been told that I make too much. I'm not really sure at this point, to be honest. I don't know much about them.
Either pay your rent or move out. If you can't afford to live there, the Kleins certainly could rent it probably shortly after you vacated, after they clean it. There are people all over St. Joe County looking for places to rent. And so each month they continue with you, they get another $1,200 behind. You indicated that you make too much, but you haven't paid any rent for May, June, and July. I don't remember what the deal was, whether you were laid off or what happened. You haven't made any payments since we saw last. What's your position?
The payment scenario was due to the broken windows, and I had 2 broken vehicles, which and I had been told to even maintain to go to work. On top of that, I have my personal loans on top of that, and I have other avenues. I mean,
and other debts.
Pays rent and I pay utilities, and due to the broken windows, I've been reluctant to pay because of children being in a home.
All right, well, let's talk about that. Legal aid is about to join us. I'm not going to excuse you from paying 3 months of rent because you have broken windows. And I don't know what the situation is, how much Mr. Patterson contributes. He's not even on the lease. You're on the lease. He's not. Apparently he and his daughters are staying there. I don't know how much he's contributing, but there is a way to stop paying your rent and pay it into escrow. But your contention is that because the windows are broken, and first of all, just because they're broken, you need to tell them they're broken, and they need to have an opportunity to deal with it. But you're in the hard position that you have to make a decision on whether to pay this rent or move. Now, when you're not paying the rent, I guess you have money to establish somewhere else, but you started to say something when I asked if you had informed them about the broken windows.
Yes, I have wrote them a letter, let them aware of it.
Mr. Spencer, you wish to weigh in on this at all?
Your Honor, yes. So I talked with Mrs. Klein after the hearing just to make sure that I was remembering correctly what she had told me. And when Ms. Bingaman moved into the property, Your Honor, there were no broken windows. And any windows that had been broken would have been the damage done by the tenant, not by my client. And I believe if Ms. Bingaman made my clients aware, it was only been here just recently, Your Honor, in June. And again, I believe that Mrs. Klein would testify that the windows were not broken when Ms. Bingaman moved into the premises, Your Honor, and not the broken windows were not caused by my client, and believe that they were caused by damage done by the tenant. So we would certainly present that as a defense, Your Honor.
Well, I find that through July, rent is $3,000.
Sir, I know the former tenant, so I know how long the windows have been broken. And you can see them from the street.
All right.
We have
Okay.
put board to prevent either from getting children.
And maybe you want to just move. This isn't the place for you. 3,000 is the rent through July of 2026. 247.43 is the balance of court costs, filing fee, service fee, and attorney fee. You have 10 days from today, which I told you last week we would use. Today is July 6th. You have until July 16th to pay that, or you're subject to being evicted. This process started some time ago in March, I think, when they served the notice to quit on you. That might be too early. Notice to quit was served on April 21st. It's now July. You haven't paid any rent at all in the last 3 months. And partial payment will not prevent the writ of eviction, and I'm not ordering any money damages at this point. If we're going to have a hearing regarding money damages, it will be at a later date. If you move, when you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. But as you indicated, you haven't paid in the last 3 months. Not because of a window, but because of other obligations and circumstances. So we have to pay the rent or move is what it boils down to. Now, if you don't pay the rent and you move, we'll have a hearing regarding who owes who how much money. And maybe there will be an issue about what you had to pay for heat. But I didn't find a need for an abatement here. So you and Mr. Patterson have to find out what you want to do next. And if you go somewhere else, it'd probably be helpful if he was actually on the lease. Now, if you do pay the rent, you get to stay there. And August rent will be due on August 1st, and the tenancy will continue. But at this point, unless you pay the rent, you're subject to being evicted in 10 days. Legal aid is here. You indicated you had tried to contact them without success. It doesn't appear that there's any emergency financing or funding coming.
Judge,
I may need.
happy to consult with her right now.
The problem is I may need you on the next cases, but we can do that. If I was going to do that, I would have set up escrow payments. I don't think 2 broken windows are sufficient for her to not pay rent for 3 months. But I've made my order and you can appeal it, ask for a stay, but I will place you in a breakout room so you can discuss this with the with the legal aid attorney, and then the other people that are here. If we need them, we may have to ask them to wait. So I'm gonna put you in a breakout room with Meg Bauer from legal aid. All right, you should be able to join it now.
Your
I
Honor,
guess
do you need me to prepare and present the order to you?
I have an order. I don't know if you presented it or my clerk did, but I've got one.
I hadn't
And I've
presented
signed
one to you yet, so if you have one, Judge, that's fine.
The clerk must have made it.
Okay.
The appeal date is also July 16th. So with Mr. Spencer, I'll see you again next time. Ms.
Okay,
Klein,
thank you.
again, you're welcome to stay and watch the proceedings.
Thank you, Your Honor.
All right. All right, next up, I've got a bunch of people in the waiting room. Let's bring them all in. Well, we're not. Let's see who all we've got here. We're done. You're free to go. All right, we've got Walnut Meadows versus Diana Villavicencio. And I think, is that you on the iPhone? And Mr. Begg, which cases are you here? He's here on Walnut Meadows. That's a Bradshaw case.
I'm on all the Bradshaw cases.
All right, well, that's unusual for them to have to get outside counsel, but here we are. Ms. Villavicencio, are you there as iPhone? Ms. Flowers, would you unmute your phone? Ms. Boyer, would you unmute yours? Now, Ms. Boyer, I was getting some terrible feedback from your channel. Yeah. Do you have 2 things on?
No, I don't.
Are you watching it on something else?
Nope, on my phone.
No, you're jamming up the works.
Let me try to turn my Wi-Fi off and just use my phone service.
All right.
Hello? Is that better?
Yes.
Is that better?
All
Okay. It must have been my Wi-Fi doing it.
It's only slightly better. It's still not slightly better. It's still not until we struggle.
Yeah.
Until we struggle. But you are all tenants in a landlord-tenant proceeding. As such, you have certain rights as a tenant. You have the right to hire a lawyer. If you cannot afford an attorney, you can see if legal aid would be willing to represent you. And Meg Bauer from legal aid is here right now, meeting with a potential tenant. Could also seek other legal advice.
Okay. Sorry, my phone keeps messing up.
Yes, I'm going to mute it.
What the hell?
Yes, I'm going to mute it. I had Marilyn Hayden flash across the screen.
Hello.
Ms. Hayden, are you, Ms. Villavicencio, I see.
Oh, okay. I just wanted to make sure.
Supposedly in here, but I can't see them. Oh, here's Marilyn Hayden. All right, for all of you, you're tenants in a landlord-tenant proceeding. As such, you have certain rights. You have the right to hire a lawyer. If you can't afford an attorney, you could see if legal aid would be available to represent you, or you could seek other legal advice. You have a right to have the matter heard here in St. Joseph County, where the property is located. It's never been an issue, but the Supreme Court says I need to tell you that. You have a right to have a jury trial. If you wish to have a jury trial, you must tell us at this first court appearance, or be prepared to file a written demand within 5 days and pay the $50 jury demand fee unless the judge waives it for your inability to pay the fee. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court could help set that up. You may be able to reach an agreement with the landlord and counsel that would result in a conditional order of dismissal, which would dismiss the case under certain terms and conditions. And if that does happen, we would ask the attorney to prepare the form, or we would assist in seeing that was prepared. If your landlord is asking you to move for non-payment of rent, you may be able to get some emergency financial assistance from the Department of Health and Human Services, Community Action Agency, Neighborhood Inc., or other potential funding source. However, right now, they don't have a lot of money. They're all underfunded. So let's start with Ms. Villavicencio. This is a 115 case. We're already half an hour, about 15 minutes behind just from the first case. This is a demand for non-payment of rent. Attorney Jay Baig is here on behalf of Walnut Meadows. And the Flemans and Bradshaws and Strongs must be swamped today. Mr. Baig often comes in on some other matters. Mr. Baig, what's the status here with Ms. Villavicencio?
Rent to retain, $3,315. Court costs $240.09 for a total of $3,555.09, Your Honor.
I have the money, but I'm just waiting on my check. It should be, they're gonna mail it out tomorrow and I'll be able to pay it. I've been sick. I've been going through some issues. I gotta have like surgery Wednesday, but I had to get my doctor's papers in so I could get my money from work, and we got them in. So now they're gonna release the money.
All right. Ms. Villavicencio, the law requires that we adjourn this matter at least 7 days. And we're getting into crunch time because I take a vacation every year in July. And I won't be here in 7 days. And every year during my vacation, I come in on Tuesday in the middle of my vacation. So I've blocked, holy smokes.
What day is Tuesday? What's the date for next Tuesday?
First.
Huh?
Tuesday, July 21st is my next court date.
It'll be paid by then. I'm waiting on the check. It should be here either Friday or Monday, they told me. They're gonna mail it out tomorrow.
To July 21. Boy, I'm gonna be busy that day at 8:15. Ms. Villavicencio, if you pay it, you don't need to come.
Okay.
That would resolve it. You also mentioned you were having some medical issues, but that gives you the 6th. That's my next available court date, and it's only available because I come in during that break. So we're going to continue this to 8:15 on July 21st. If you pay everything, You don't need to be here. If
It'll
you
be
don't,
paid by then, cause I'm waiting, they said the check, they gonna send it out tomorrow, cause I got all my doctor papers and gave it to my job. And then they'll mail a check out tomorrow, and they said it'll be here about Friday or Monday. They said 5 business days, so.
my other always recommendation is stay in contact with your manager.
Okay, all
All right, good luck to you.
right,
You're
thank
good
you.
to go.
All right,
All right, we next have Walnut Meadows versus Jasmine Flowers. Jasmine Flowers is also here. Ms. Flowers, can you hear me?
Yes, I can.
All right, let's talk about your case. It's also a non-payment of rent. Mr. Begg, what's the arrearage here?
Rent to retain $2,346.95. Court costs $240.09, for a total of $2,587.04.
Ms. Flowers, what's your position here?
I had lost my job, but I just got a new job, so I've been slowly paying it off with the checks I've been getting. I get paid weekly, so I've been paying it off weekly.
What's your new job?
I work at Amazon.
At where?
Amazon?
Okay. Now, as I told the last tenant, I have to adjourn this at least 7 days. I'm going to take next week off and until the week after that. So the next date I have available is 21st of July. We're going to make that at 8:20. Now, if you pay this all off, you don't need to come. If you don't pay it all off, then you need to be here and we need to discuss it further. We'll see how much of a dent you've made on it between now and then. You would get 10 days from the 21st of July to pay the balance or be subject to being evicted. That would be till July 31st, the last day of the month. Your landlord can agree to work with you to try to get caught up on this, but they don't have to. Have you spoken to the manager about this?
I have not.
What do you mean? You've tried but not been able to?
Yeah. I work 10 hours a day, so by the time to contact her, she's not.
All right, well, let's talk about this. You have to pay this entire amount. Let's say you paid 2,000 of it, you still owe 587. You would still be subject to being evicted unless you pay the entire amount. And on the very next day, August 1st, another month's rent is going to be due. So I would suggest you try to make a time to communicate with your your rental manager, or let her know what the deal is. Because they could agree that you'd pay 500 here extra, 500 extra. Apparently you haven't paid anything in a while. But you have to pay the entire amount to cure it, or you could be subject to being evicted. So
Okay.
we're having more than a 7-day adjournment. We're having a 15-day adjournment. And we'll see what position you're in at that time. So
Okay.
maybe get some overtime. Anyway, I will see you on July 21st. That's a Tuesday. That's an odd day, Meg, for our proceedings. Tuesday, July 21st. It's not a
Thank you.
normal landlord-tenant day.
Thank you.
But I come in every year on that Tuesday and do landlord-tenant in the morning and sobriety court in the afternoon. And it's all right. All right, Ms. Flowers, you have any questions?
Nope.
All All right, you're good to go. Thank you.
Okay.
All right, I don't see Mr. Roberts. Let's stay with Mr. Begg for a minute. It is 37. Somehow we got way behind schedule. TR Limited, this is Rancor. Is anyone here on behalf of Amber Rancor? She's here live with me in the courtroom. Miss Rancor, you just stay where you are for just a minute. Miss Boyer, we're going to try to limp through this with your web jam and sound, but would you go ahead and unmute your mic?
Yeah, I don't know what's going on.
You've got more than one.
You've got more than one thing.
My grandson is watching his tablet in the living room, but that's about the only thing.
That's it.
That's it.
Is that it? Okay, let me go stop him. Hold on. I'm sorry. Elijah, you gotta shut your phone off for right now.
Okay.
She's got it. Ow.
Are you still there? That didn't fix it.
That didn't
All
fix
right. Well, Mr. Begg, what's the arrearage here?
$1,206 even. $184 even in cost. Total $1,309 even.
Give me that again.
Give me that.
$1,309 even.
1,309.
309.
State claim is behind.
What's your position?
Off for a while because I had to have my toe.
Do we have the right one? This
Week.
Do we have the right one? This is supposed to be Amber.
Oh.
This is Amber.
I'm sorry,
Boyer.
my phone.
This is Amber Boyer.
Yes.
And Three Rivers.
What is going on?
I thought this was Amber Rancor.
No, Miss Rancor is seated, and we're going to deal her with in a minute. I've given these people their rights, so rather than do it, I'm going to finish the ones we did. This is Amber Boyer and Walnut Meadows.
Then the rent to retain is $2,505 even. Court costs $240.09 for a total of $2,745.09.
I got cut off somehow.
Yes, you're in here twice. But go ahead. They claim your rent is $2,505. What's your response?
I have been off work for a little bit. I ended up having to have my toe amputated. I'm back to work. We started back to work last week, and if I can get 3 weeks, I can be 100% caught up and ready to pay August rent.
All right, that's great. I'm going to continue this.
Okay.
To July 21st at 8:20. 8:30. I'm really.
8:30.
Yes, 8:30 a.m. That's a Tuesday. That's an odd day for landlord-tenant cases, but that's what we got. So I will deal with your matter on July 21st at 8:30. If you pay everything, then you don't need to come. If you don't pay, then now this, you came in on a different device, and this one is better than what we were on before. So the echo is, but you're in there twice.
My phone kept cutting me off. I don't know what was going on. So.
All right. Well, July 21st at 8:30. Stay in contact with your manager. If it's paid, we don't need to be here, but if it isn't, we'll discuss it further at that time.
Okay. Thank you very much.
All right. Thank you.
All right. Have a good day.
Let's see where we are here. We've got a little sideways. 125 is Christine's. Marilyn Hayden. And we'll come back to Miss Rancor. Is anyone here on behalf of Roosevelt Roberts? Does not appear that he is. He was here previously. This matter was continued to 125. It's now 144. 261152 Finrick LLC versus Roosevelt Roberts and all other occupants. He was here on June 29th, indicated he's working at Iceberg, plan to pay and stay. Continue the matter until today. Ms. Yancey's given me the breakdown. Rent through July with the late fees attached is $2,670. Is that correct?
Yes, Your Honor. We had a July in as we are now July 6th, so it's a little bit different in figures than we were in the hearing.
Would you call the hall for Roosevelt Roberts? I expected him to be here. He hasn't paid anything?
No, Your Honor.
All right, I find by default, according to Deputy Teflinger, he's not here. He owes $2,670 through July. Court costs of $180.85 for a total of $2,858.85. That is due by July 16th. It's also the appeal date. He has until July 16th to appeal or pay the rent. No money damage entered at this time. Partial payment will not prevent the writ of eviction. And we'll take care of that. Holly Baugh or Katie Bidwell?
Ms. Bidwell is moved out, Your Honor.
Yes, I think we learned that last week. This matter is set for 1:30. Same thing, we continued the matter. We learned that Ms. Bidwell had moved. This was filed as a just cause termination, loud noise and otherwise, and neither defendant has appeared. Ms. Finnerman, are they still there?
Holly is, Your Honor.
All right. Well, she has 10 days to vacate or she's subject to default. She was here at the hearing a week ago and she knew the hearing was today. Christine, you make my life so much easier with these pre-prepared, accurate judgments.
Judge,
and your, yes?
just for the record, She did complete an application with us. I requested her paperwork the same day as the prior hearing. She emailed or messaged that to us late yesterday, I think it was. So I'm surprised to see that she's not here. I actually believe she messaged some of it to us this morning. I did not
Let's make
indicate.
sure I don't have somebody in the waiting room that I'm missing. She's not here.
And to clarify or confirm, it was all last night around 10. I did not indicate that I was appearing on her behalf, but I am surprised that she's not here.
Well, we'll see what develops, but she isn't here and she's subject to default.
Yep.
Thank you, Your Honor.
All right.
Thank you, Carissa.
Thank you.
All right, thank you, Christine. All right, now we've got a couple. We've got Amber Rancor. Would you come up and have a seat, please? We got a little out of sequence. I took the defaults to help us catch up. And I've got Mr. Werber here for a general civil matter. And I've got Ms. Hayden here. She's Bank of America on a summary disposition motion. And Eugenia Wolf is here on a installment payment. So I haven't forgotten that you're here. We're just going to get up to speed on our landlord tenant cases. Nikki Berenger is here, and I'm not sure what she's here on.
This is Alice Nickerson. I'm appearing for Attorney Buckland for Sturgis Housing Commission versus Gary Norris.
Yes. And that matter is set for 1:35. And there's no one here on behalf of Gary Norris.
No, Gary is not there. He told the office that he couldn't make it.
All right. This is a subject close to Meg and my heart, bed bugs, and other issues. That's a notice of termination of tenancy that was personally served on the defendant for multiple lease violations, including bed bugs and other matters. Notice to quit was served on April 2nd. The defendant is not present. Alice Nickerson is here from the Buckland Law Firm. Ms. Nickerson, are you going to ask for a default?
I would move for entry of a default that would grant plaintiff possession. And I have costs, which including the $75 attorney fee of $188.62. There was $58.62 for a process server fee and $55 for a file.
Well, this is not a non-payment of rent case. Let me see.
It is not.
And no, he didn't request money damages. So what I need is a judgment that says he has to vacate by July 16th. And the appeal period is July 16th. I looked, I did not see a judgment in here. So if you would email me a judgment at 3bcivil@stjosephcountymi.gov, I will sign it He has 10 days to vacate or he's subject to being evicted unless he appeals.
We will do that judgment and send it right.
All right, thank you.
Thank you, Your Honor.
All right, let's do Miss Rancor. We kind of jumped around a little bit. We had several no-shows. This was actually set for 125. I'm not sure. I believe she was here by 125. But she's the only one I hadn't advised her for rights. So Miss Rancor, you're a tenant in a landlord-tenant case. Your landlord is asking you to move or pay the rent. You have a right to hire a lawyer in that kind of a case. If you can't afford a lawyer, you can ask legal aid if they would be willing to represent you in this matter if you're eligible. Or you can seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to a jury trial. If you wish to have a jury trial, you must tell me at this court appearance or file a written demand within 5 days on the jury demand form and pay the $50 fee unless the judge waives your fee for your inability to pay it. If you need financial assistance to help pay the rent, you may be eligible for some financial help from the Michigan Department of Health and Human Services, Community Action Agency, Neighborhood Inc., or other funding source to pay the rent. You may be willing, and if both parties are willing, I could refer the matter for mediation, an attempt to mediate a settlement. And finally, if both parties could reach an agreement, they could file something called a conditional order of dismissal. This is filed as a demand for non-payment of rent. Rent is $611 per month. Mr. Baig is here on behalf of the Bradshaw Law Firm. Mr. Baig, what's the status here?
Rent to retain, $1,206 even. Court cost of $184 for a total of $1,309 even.
I got two things. I got a letter handed to me. My name is Sandra Gearhart. I live in apartment B613. I am witness that no communication with management through October to April. Sandra Gearhart. There's apparently somebody here from the apartments, which will be Shana Taylor. Then I got a bunch of stuff handed to me like a few seconds ago that Ms. Rancor has filed. Raising a number of issues. So Ms. Rancor, in your letter, now Mr. Baig hasn't seen any of this stuff because we just got it. You've got some issues. Community Action Agency may be able to assist with your rent.
Yes, sir.
But there are issues about requalification and that sort of thing.
Mm-hmm.
Is that true?
Yeah, Shayna had reached out to me this morning just before court, and she told me that the higher ups had gotten a hold of them and that they were going to help me pay my rent.
All right, very good. In your letter, you indicated you lost your job, but now you have a new job.
I don't have a new job.
Where were you working?
I was working at Graham's Cannabis in Three Rivers, Michigan.
It closed down?
No, I was laid off. They slowly reduced my hours and then they just took me off the schedule.
Well, that doesn't even exist anymore, does it?
Yeah.
Where is it?
It's over by Label Shopper in Three Rivers, right behind Wendy's.
I didn't know there was one there. All right. Shayna, have you received information from Community Action Agency?
I did. I've sent it up to corporate and corporate filled it out and sent it back. We sent it back to community action today.
All right, well, let's continue this matter. I'm really overbooking myself because I haven't done Friday's cases yet. I have to put them somewhere. So there were a bunch of cases scheduled in there. And now I've got 2 second hearings, but we'll continue this to 8:40 on July 21st. Stay in contact with Community Action Agency, stay in contact with your manager. I will see that Mr. Bradshaw's office gets a copy of the stuff that you filed with us. And it sounds like you're gonna get some emergency help, and that's a good thing. One thing I need to tell you, you need to pay the entire amount. A partial payment will not prevent the writ of eviction. So you will, not an inordinate amount, $1,309, let's say they give you $1,000. You're still responsible for the $309. Now, if you need a recertification because of your loss of income, you need to get in there with your manager and deal with that. Right now, the rent is $611 a month. That's not market rate. So have you done that? Started the recertification?
Yes, sir. We did that. And then we also recertified this morning because I'm receiving unemployment benefits now.
All right, very good. Stay in contact with your manager, stay in contact with Neighborhood Inc. We'll continue this to July 21st at 8:40 a.m. You're welcome to Zoom in or come in live like you did today.
Okay.
All right, you have any questions? All right, you're free to go.
Okay, thank you.
Thank you, Your Honor. I'll stick around for credit acceptance versus Wolf. I'm on that one.
All right, that's the kind of thing I usually see on. So let's deal with Mr. Werber. He's very patient. And then we'll boy, I sure had. I have one more case. Phyllis Bell. I don't know where that is. Elaine, I don't have Phyllis Bell, an SP hearing. It's set for 2. I'm not sure what that is, but I don't have it. Elaine. All right, thank you, Ross. Let's talk about our 2 general civil motions. Marilyn Hayden is here with us. And I'm going to bring this next gentleman in. He's an hour early. Miss Hayden, could you unmute your microphone?
Yes, sir.
All right, this is entitled Bank of America versus Maryland Hayden. Ms. Hayden, you were very conscientious. I see you practiced a little bit over the weekend about logging in. I think you tried earlier today. The esteemed Mr. Jeff Werber is here on behalf of Bank of America. And this is a motion for summary disposition. Well, I'll explain in a minute. Mr. Kemp?
Yes.
Your hearing isn't until 3 o'clock.
Oh, 3 o'clock. Sorry. Okay.
So it's an hour from now. So join us again at just before 3.
Thank you.
All right. This is a claim in general civil court. It's file 26280GC. Bank of America versus Marilyn Hayden. The amount claimed is $3,137.72. Ms. Hayden was served with a lawsuit and she filed an answer, a general denial, denying the allegations. That gets you past the default, but it doesn't get you past the motion for summary disposition. All right. A motion for summary disposition is something that lawyers and judges use all the time. And several times a week, including 3 times today, I get the opportunity to explain the concept to lay people. There's a Michigan Court Rule 2.116 that addresses this. The 2 particular sections are C9 and C10. They're contained in Mr. Werber's brief. And when you file an answer saying, I deny, that gets you past the default. But they contend you haven't stated a defense. There is no material issue of fact. So a judgment should simply enter on their behalf. Mr. Werber, is that your position?
That is correct, Your Honor. The only thing I will state to the court is defendant filed an answer, but in fact, she agreed with almost all the paragraphs except for 2 where she said she didn't know. So she didn't even deny anything here. I think she's agreeing that she owes the money.
That is correct.
Would you like to set up a payment plan?
I am unable to do that right now due to medical issues. I am unable to work. I worked a few days in April and had a relapse, and I haven't, my medical issues started back April 2025. I tried working in late September and October and had another relapse. So at this point, I am unable to work.
All right, I'm simply going to enter the order finding that you owe this money. Okay. Now, if you don't have any money, you don't have any money. They can't take Social Security or other, but the debt isn't going to go away. It's good for 10 years. It can be renewed after that for an additional 10. But I find that damages in the amount of $3,137.72, court costs the amount of $152.75. Total is $3,290.47. Now, the address and contact information from Weber and Olsees is on the judgment. Right now, you're not in a position to make any payments or negotiate a settlement. We're simply going to enter the order. Okay. If you get better medical health, you can contact Weber and Olsees and discuss some sort of payment plan. But essentially, you acknowledge the debt.
Exactly. When you get in a position and you want to set up a payment plan, absolutely call my office.
All right, Ms. Hayden, do you have any questions?
No, sir.
People don't decide, hey, I think I'll get sick. It turns your world upside down. And and some, you know, I see it all the time. Car payments, house payments, other debt. All right, I've entered the order. You'll get a copy of it. Are you still at the Garber Road address?
Yes, sir.
All right. You're good to go. Thank you, Mr. Werber. Thank you for your patience.
Thanks, Your Honor. Have a good rest of your day.
All right, we're working on it. I understand that the 2 o'clock hearing is off. So what we're left with is Credit Acceptance Corporation versus Eugenia Wolf. Ms. Hayden, I'll remove you. That's a sad circumstance. This is file number 19732GC. It's entitled Credit Acceptance Corporation versus Eugenia Wolf. The original claim was for $10,758.60. Attorney Jay Baig is here for the plaintiff.
Your Honor, I see that they want $100 a month. If they're willing to go up to $140 a month, I can agree to that.
All right, well, that's an awfully large debt for a $100 a month payment. So what I almost always do, Ms. Wolf, is set these for a hearing and see if the parties can come to an agreed upon figure. If you can agree to $140 a month, they'll live with that. Can you do that?
Yes, Your Honor, that would be fine.
All right, I'm gonna set this for a $140 payment every month. Can you start August 1st?
Yes, sir.
Appreciate your patience. You got to watch some landlord-tenant stuff and some other things. We set things on very short time frames, close together, and sometimes we run into backups. This was set for 145, it's 209, so by our standard, that's not very bad. But I find it beneficial to just get both parties here at the same time. Once we actually got here, it took 2 minutes to settle it. Now, especially that we're doing things by Zoom, you didn't have to come all the way over here. So this will forestall any other sort of garnishment from your place of employment. They could still garnish your income tax from the state of Michigan, but they generally don't. But this will forestall any garnishment as long as you pay $140 each month. Rusin and Varchetti and Olivier, their number and information is included on the order, the information that you have. So hopefully everybody can live with that. It's still going to take a long time to pay a debt that size off, but you have to live. So do you have any questions?
No, sir, I do not.
All right, you're good to go. Thank you. Mr. Baig,
Thank you, Judge.
Got your money's worth today, so thank you for that. I'll see you next time.
See you next time. Thank you, Judge.
All right, thank you.
Thank you, Your Honor. You have a great day.
All right, I'm working on it. Meg, that's
Okay.
all the legal aid matters I have.
Yep, I'll see you on Friday.
All right, now I've crammed I know Tuesdays are often a very busy day for you. So I'm not sure how that's gonna work, but it's already packed. I usually start at 9. I started at 8:15. I've also somehow got 2 sentences in there.
Oh, I had it marked off apparently in my ultimate wisdom or infinite wisdom or whatever. You must have mentioned it previously. I already had it.
I think I did. I do it every year. I take these 2 weeks of July and come in on the Tuesday of the second week, which often irks my family, but it keeps things moving and I don't want to dump this stuff on Judge Pattison. I also come in several times and sign orders, again, not to burden him. All right, thank you for your help. We will take a recess until 3 o'clock when we start our small claims matters.
You hand a contractor a $6,000 deposit. Months go by, no work is done, and your money completely disappears. So, who's responsible? That was the question at the center of this unforgettable courtroom case. A husband and wife sued a contractor after paying a $6,000 deposit to remodel their home. According to the homeowners, the contractor never started the project, and and never returned their money. When the judge asked if that was true, the contractor didn't deny it. Instead, he explained that shortly after receiving the deposit, he became seriously ill. He spent months in the hospital and was eventually placed on permanent disability. He claimed the money had already been paid to a supplier for building materials, but when the job was canceled, the supplier never refunded the money. He insisted he had been calling them repeatedly, even on the morning of the hearing, trying to get the refund. But the judge wasn't convinced. He said that while illness was unfortunate, it didn't erase responsibility. Then, the hearing took an unexpected turn. The judge revealed that this wasn't the contractor's first lawsuit. In fact, he told the courtroom the contractor had been sued multiple times before over similar issues. Even more shocking, the judge pointed out that the contractor wasn't properly licensed to perform the type of construction work he had been advertising. Then came the strongest moment of the hearing. The judge explained that when contractors take a customer's money and fail to use it properly, it can cross the line from a civil dispute into a criminal offense. He even described how prosecutors have charged similar conduct as a felony